All right, I guess I can start. Good evening, everyone. My name is Abhishek Jain, and I'm pleased to invite you all to the first episode of the Moot Court competition series by Preparing to Triumph. Towards the end of this session, we will also be having a Q&A session for which I would request you all to put your questions in the live chat box. Today, we are very fortunate to have with us Ashley Clasen and Sanya Kishwar, who were part of the winning team for the Willem C International Commercial Arbitration Moot Court competition in 2019. In today's session, they will be speaking in detail about the WIS Vienna Moot, how to prepare for it, as well as the opportunities available both during and after participating in this moot. I would now like to them to begin this session.
Hello, everybody. My name is Ashley. I was part of the team as was previously stated. There's a lot that goes into the moot court competition, and I think it's best to start with one of the talking points, which was who should participate. I think anyone interested in international commercial arbitration, clearly, because that's what the WIS Moot focuses on. But also anybody who has an interest just internationally in general or commercial law in general. My big pull towards this competition was a love of the world. I really wanted to see another country, and I knew that this team allowed me to access that. So I tried out very naively, thinking I really just wanted to go to Vienna, not realizing the workload that it would entail or that I would actually really come to love the topic that we would be discussing. I don't know if you want to talk, Sanya, about what brought you to this moot.
Yeah, thank you, Ashley. So as already introduced, I'm Sanya Kishwar, and I was one of the speakers from the side of procedure in the 26th edition of WIS Moot. So starting with who should participate, I personally was pursuing my LL.M, and we were eligible to participate. I know most of the universities in India wouldn't allow the LL.M students to participate. So I would say that the eligibility plays a major role over here. So you should check with your individual universities in that regard. But apart from that, I personally was very naive to the this course or this subject of international commercial arbitration. My interest was in international law, and that actually brought me to participate in this competition, because that was the only competition that LL.Ms were eligible to participate in. I was actually thinking about the Phillips CGS up first, but we were not eligible. So, the only thing that I got to participate in, and also because I was a moot court enthusiast, so I was looking for opportunities. And so I saw this moot court, and so I saw that subject matter was very new to me. So I wanted to try my hands at that. So yeah, anyone who is a moot court enthusiast is open to the arena of exploring new subjects. Maybe they could also feel free to participate, and it's a very great learning opportunity. Specifically now during the COVID time, you might not get the opportunity to visit other countries, but then the number of people you meet, the number of contacts you get through this opportunity is just great, and it's worth it. Yeah,
that's a very good point. I'm friends with people from probably, I'd say, at least 15 different countries that I've kept in contact with, and it's been almost 2 years now. Not to mention my teammates becoming pretty much my family, because you spend almost every waking hour with them once you hit the ground running and you get through your research phase. But to take a step back, the word international commercial arbitration, or the phrase, could be intimidating. It's big, it's lengthy. What does that consist of? To give an example, there's been a couple of different problems that I'm familiar with that would kind of illustrate what this competition entails. So for our year, we were actually arguing over a contract for frozen racehorse semen. The big focus of this competition is the sale of goods between companies or two parties that are part of different countries. So how are they going to decide whose law should apply when they're drafting the contract? Should they be before a court, or is arbitration more favorable where they can actually meet their contract or create the contract? If I'm a party in the US and Sanya is a party in Peru, I'm naturally going to prefer my own courts, as is she. We would never reach an agreement on a contract if we didn't have this alternative dispute resolution. So our year focused on frozen racehorse semen, but to show you the variety, the year before us was over, I believe, a cake and a company that makes or manufactures different products that are needed for a bakery. And the year before that was over a propeller piece for airplanes. So as you can see, there's a wide variety of goods that this covers. And each year is very different. And it's a lot of fun because not only are you learning about the applicable international laws and the rules that are associated with it, you're learning about different industries. Never in my life did I think that I would know as much as I do about racehorses and breeding racehorses, but it became very interesting. I don't know if you want to touch on that at all, Sanya.
Yeah. So our memories with regard to racehorse is a bit funny as well, because I come from a science background as well due to my integrated course in science and law. So we had a lot of industry-based opinions coming from my side as well. The rate of semen getting frozen, etc., etc. So that also led to a lot of spurts of laughter in our team discussions. So keeping that aside, with regard to what one should expect from this competition, so as Ashley also pointed out, it's regarding international commercial arbitration. So it will most definitely always have a sale of goods as a question. So technically, this is something which has to be of an international nature. So it will include 2 different states. And when I use the word state, it means 2 different countries in the international context. And now it has to be something related to arbitration. So if you're a procedural speaker, so you must be ready to have background knowledge about what are the ingredients of an arbitration agreement. So that's the main thing that a procedural speaker should be well read about. For the substance, the main point of research is regarding the CISG, which is their convention that. The Convention on the International Sale of Goods. And very interestingly, India has not ratified that, so we are not made to read about that in our schools. But that's something, again, our whole life is about learning, so we'll get something new to learn from here. But as the name suggests, international commercial arbitration, so we need to be ready about something different from the things that we experience in our litigation, etc., etc. So arbitration is technically like a settlement between 2 parties. It's more the nature of the arguments are like. It just sounds, if you are persuading someone to listen to what you are saying, as if you are in a business meeting and you are putting forth your points. The reason being that the arbitrator, as well as the members of the arbitrator, as well as the president. Generally, in a tribunal, there are 3 arbitrators. One chosen from each side, and both of them chose one president. However, the numbers might vary because, it all is related to the arbitration agreement, and it depends on the parties, however they might choose. But, generally, the thing is that you are before someone, you are going to persuade someone with your arguments, and those people are the ones who you have chosen. The thing that you have to keep in your mind is that you have to persuade at least 2 people to win. If there is a 3 tribunal, if it's a 3-member tribunal, the one who will be chosen by you, technically, as the human psychology goes, he will give the judgment in your favor, the decision in your favor. But then you always have to keep this in mind. Even when you are arguing, you have to persuade 2 people to be on your side, to get a majority. That's something that will also help you prepare your mind for the competition. But it's just something I wanted to add upon to give a background of what the subject matter is. So, yeah.
To clarify, in this competition particularly, there will always be 3 arbitrators, and you will always have a question of procedure and a question of substance. So when she refers to those, whether you're a substance speaker or procedure speaker, that's going to go to what your team needs and what your preference is. But there's going to be a question on the jurisdiction, where you're presiding is permitted in your arbitration agreement, and whether the question that's being presented is permitted, whether these arbitrators are allowed, through your contract. There's there are different questions. So you don't really know. There's obviously a narrow scope because it's going to go towards jurisdiction, but there's no way to know until the problem comes out, particularly what your year is going to face on, the question's going to face. The substance side of it goes more to the actual material goods. And there's going to be ambiguity in your contract. So for our contract, the ambiguity was a tariff that came about after the performance of the contract already started. And there was no discussion as to which party was going to bear the brunt of this tariff. And the contract didn't speak directly to it. It was purposely drafted ambiguously to give us a question to focus on and gave us some language that we had to research to see, okay, if this is in the contract, what does that say about an unforeseen or unforeseeable event that occurs? So speaking of these issues, like all legal practices, you need to be able to issue spot. You're going to get 52, give or take, pages of emails, of information, of the actual contract between the parties, and you have to figure out what the issue is and what laws apply. So the way our team started was before we even got the question itself, we looked at the rules that were going to be applicable and became well-versed in these rules. When I say well-versed, I mean we sat for hours going through one by one, reading each rule and picking them apart. Each year, the BSc Moot changes what laws will apply. They get promoted, for lack of a better term. So for our year, it was the HKIAC.
HKIAC, yeah.
Thank you. It's been a little bit. It was Hong Kong's international arbitration rules. So we pulled up those rules. Our biggest guess was if we can find an ambiguity or a discrepancy in the rules where something was unclear, the problem was likely going to focus around that. So we went through the rules very slowly. We went through the CISG very slowly, picking it apart, reading about it, learning about the background. To be able to argue based on these rules, you need to know the rules inside and out and understand where they are going to apply. And it gives you a better chance at guessing what your question is going to focus on. So that's where we started with our research. So before the problem even came out, we hit the ground running, looking at the different rules and what was applicable. The other thing we did was we started learning what characteristics should be displayed and how we should present ourselves during an international arbitration proceeding. So coming from a U.S. background, this was very different for me. If any of you are familiar with U.S. law, U.S. courts, the way our jurisdiction works, we are very animated in court. We use our hands, we speak, we point to props. It's almost like a drama to an extent. Arbitration is not like that. So it was a challenge for me to learn to present myself differently. It's very stoic. We learned how we're supposed to sit. You're at the, basic things. You sit at the edge of your chair. You wear neutral makeup. You don't draw any attention to yourself. So like my lipstick, my eyeshadow today would not be acceptable. It's a distraction. Big jewelry. I know one of our teammates was married. She has a beautiful ring. She would turn it inwards. So only the bar of her ring was facing out towards the judges because you don't want people to now be distracted by something shiny you're wearing and they're not listening to you speak. They lose their train of thought. They lose their focus and they potentially lose their interest. So we had a lot of boot camps just learning how to present ourselves before we got the problem, trying to start mastering things that we could do before we actually knew what we were going to be arguing, because they're all very important components. And one other thing that we did too, which was very important, we did a lot of team building. So our team had a very large advantage. Because our LL.Ms are allowed to compete in the US, our team of 8 people was composed of 4 US JD students and 4 LL.M. Obviously, that was going to cause a lot of conflict at first as well, because we come from such different practices. You're talking about, a common law practice versus civil law practice. So the way we want to approach things naturally are going to be different because we're trained differently. In the end, this became a very big advantage for us because you never know the arbitrators that you face in the competition. They're going to vary. Their backgrounds and what jurisdictions they come from, what kind of practices they come from are going to vary. So it ends up being a strong suit for us to have both that civil law practice as well as the common law practice. But it also caused a hurdle at the beginning. We really had to get to know each other, get to trust each other and know, what our strengths are. So we did a lot of team building. So a lot goes into this competition before you even get the problem if you want to perform well. You really want to hit the ground running, which means you need to give yourself the best start that you can possibly get before that problem is released. I don't know if you want to weigh on that at all, Sanya.
Yeah, thank you, Ashley. Those were excellent points. Just one thing that I would like to add here. So my particular preparation, even before we got into dissecting the HKIAC rules, was I started with knowing what international commercial arbitration is, what is an arbitration agreement, what is the correct law governing an arbitration agreement. That all helped me because we even before we had started, we knew that all the years, we get one or two similar types of questions, specifically for the procedure speakers. We have to get one or two questions from the tribunal regarding what do you think is the correct law applicable and why do you think this law is the correct law applicable to the arbitration agreement. So it kind of helped me out because one of our main issues from the side of procedure was regarding determining which law was the correct law applicable to the arbitration agreement. And we had to go through an in-depth study of the different types of law applicable to an arbitration proceeding. And, even before you start reading about the specific rules that govern the arbitration proceeding, you need to know more about the different components of an arbitration clause, the different background information regarding arbitration itself. For example, even in some of the countries in India, we might not have ever heard the term CISG. So I particularly would say if I were to start my preparation, even before going into the rules that have to govern our proceeding for that year, I would prefer my students to have a copy of an easy book on CISG and the bare provisions of CISG, have them go with the, have them go around the convention and let them prepare with the basics. In the Indian jurisdiction, it's a bit more difficult for us because we have less faculties who specialize in international commercial arbitration. And that's something that we could work around. Many universities invite people from other jurisdictions to help us with that. And that's something that the universities can go around with. The second point which Ashley spoke about, that's regarding team building, and specifically in the context of India, I would like to tell you all, I know how our teams function in India, so that's something that I wouldn't suggest our teams to do, because if we become families in our teams in India, that just doesn't help. That just doesn't help in India particularly. So, we all will be Indians in an Indian team. And if the Indian students would be watching out there, we know how much we hate each other inside when we are even working together with our fellow Indians. We know that. That's something that goes across India. At a later stage, every team, technically, literally every team, Indian team that I have seen, they grow sour at the end. And that's very natural for us Indians. So that's something that I wouldn't suggest for Indians, because that will just be a wastage of time for us as Indians. What I would say that will work for our teams, you just need to cram your heads into the books. You need to get the points, and then you can, start practicing. And as coaches, in the Indian teams, I do see many of the teams do not have coaches. We have our seniors guiding us. So whoever the coach is, if it's a faculty member, or even if it's a senior, that's the way that I did with one of the teams that I was coaching for a part of this year from India as well. So we need to make it very clear in the beginning that there will be some change in the order of speakers, or the selection of speakers. So as a coach, you have to be very, 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 open with your team. You don't have to, make plans behind their backs and not tell them. That's something that goes on in India very much, specifically if the coaches are Indians. So, that's something that we can try figuring out. Most of the teams that I have seen breaking at the end, it's because of the trust issues that we have. Specifically in the team that I was coaching for a part of the year, I did see that some people just left in the middle because they were not able to adjust with having a senior coach them. So they were like, oh, I'm in the third year, that person is in the fourth year, how come he coach me? So these things are we need to work out, and just building team building is a myth in India, to be honest. So yeah, that's just one thing that I wanted to speak regarding your point in the Indian context, because I feel that the audience at large will be the Indian teams over here. Yeah.
So then our next step was, once the problem landed, once it was released, we took some time, about 2 or 3 days, to read it on our own. And then we came together as a group and quite literally read it out loud, page by page, trying to dissect it and trying to understand, okay, could this potentially be an issue? Could this potentially be an issue? And that part was endless in the sense that there were a lot of issues. The writers of these problems purposely put red herrings in. They want to see if you get distracted from the main issue with little issues that really aren't the primary focus. So be aware of those, but don't necessarily look over them, because they could become smaller punching points for you to use in your argument later. They're not going to be the focus of your argument, but nothing shows that you know the problem inside and out by saying, this is our central focus, but I'm going to jab you here and there when it fits, either in my argument or questions that are presented by the arbitrators. So we broke it down, and we spent several days just going through the problem itself. And I think one thing we did that's different, and I could be wrong because I've never been on another team, that I'm not sure other teams do. I'm going to guess that they don't do it to the extent we did. I think people do their research and jump into the memo. We started with a research memo. And it's not like we spent a week or two on a research memo. We took every possible issue that we found, whether it was a red herring or not, and wrote a memo that ended up being about 65 pages long of all our research. Procedure went off and did their research on their questions. Substance went off and broke up the research. And we did it point by point. We said, okay, procedure has 1, 2, 3, 4, 5, 6 issues. You know, you take this issue in research, and substance did the same thing. I will say that I ended up with a folder on my computer for research memo and subfolders for each actual issue that we were addressing, because organization is going to be key at this point as well. It all starts to get mixed in your head, and trying to keep everything separate with what went towards what point can be very difficult. So I highly suggest having some sort of organizational pattern. So, you know, the research that I'm doing is towards this issue. I'm going to designate it and put it here. And once we did the research, we tied it all together doing a memo and trying to hit every point that we thought was a particular issue that needed to be addressed, filling in all the research. And at that time too, doing all of our, in the US it's blue booking, but basically our citations, because everybody knows no matter what continent you're on, those are a pain in the butt to do and make sure that they're done right. So when we did it with our research memo, it made it a lot easier when we said, okay, we're going to take this piece, to put in our claimant's memo, our respondent's memo. We already had that done, and it was easy to just copy and paste it in. And it also kind of gave us a roadmap when we started writing our memos. We kind of laid out our research with what goes with what issue, and then actually filled in the substance around it, expounding on the research that we did. To back up and go to that point, this competition requires that you submit a claimant memo. They have a page limit on it. Or no, was it minimum or maximum, Sanya? I don't remember.
It was a maximum of 35.
It was a maximum. Because I'm thinking, so the actual memo itself has a maximum limit. It's going to technically exceed that when you count the research at the end, when you're doing all of your citing. And then after the claimant memos due, they have a respondent memo that they require about a month and a half later, give or take. It might be closer to about a month. I don't know about other countries. For the US, that conveniently fell right in finals week. Our research or our claimant memo was due during our semester or fall semester finals, which was absolutely lovely. And then the other one was due right after winter break. So we were working over Christmas break to get our respondent memo done. That our research memo probably took away 5 weeks worth of writing that we could have put towards our claimant memo to get it done. But I think in the long run, it helped us because it gave us that outline and we weren't just rambling here and there. And, oh, well, I found this and it kind of fits here. And I found this. And doing the research as we wrote, it tailored us to really think out each issue and what our response was going to be. I don't know if you want to add to that, Sanya.
Yeah, so the first point that you told about some of the red herrings, it was really interesting in our moot problem as well. So we had a mentioning of the instant trial rules on transparency, but that was just not something that we were referring to. However, we had to be prepared upon that because we faced that in as a constant question coming from most of the arbitrators. So yes, very well as you pointed it out, Ashley, that we do have to be prepared on the red headings as well, and just not leave them unattended, because we might end up getting questions. Regarding the memo, that all the points you covered very well. Just one or two additions that I could recall. So when you talked about citations, so we actually had the page limit for arguments, and most of our pages, our memo actually went up to 65 pages, because we had those long table of authorities. So that's something that I would like to focus up. So a very good memo will have a lot of authorities and good authorities, and not just, you don't just have to cite the authorities, but you actually have to use. So you have to present a reason why you are using those authorities. You just can't just put a name over there and not even refer to that or explain why you are using them. A typical mistake that Indian students do in forming paragraphs of argument is that they do not actually have an opening statement and a closing statement and just put all the sources there. It just looks like a book. That's not something that we want in Wiz. So we have to, one of my professors in University of Leeds very nicely put out how a typical paragraph should look like. So you tell them what you have to tell them, you tell them, and then you again tell them what you told them. So it has to start with an introductory statement as to what my argument is. So this tribunal should not adapt the contract because A, B, C. You can set out your roadmap over there in an introductory line, and then you can attempt each of the sub-issues and back your argument with sources, citations, etc., and link them with the facts of the instant case, and then draw a conclusion. Therefore, this tribunal should not adapt the contract. So that's one of the mistakes that Indian students do, is how they divide the paragraphs in their memos. I also had the chance of checking a few memos before they were being submitted, all of them from Indian teams, and I saw this one constant thing that they were struggling with, how to divide a paragraph.
If I can add to just quickly, sorry, Sanya, if that's an issue that you know your team's going to face, or you're from an area that notoriously has that issue, maybe designate some of that time before the memo comes out to reading about legal writing and how to break it down and practice it. Just pick out a random issue and practice writing in that format. Because I know that's heavily drilled into the U.S. Legal programs. But if that's something that you think is going to be a weakness, you have time. The problem doesn't drop till October. So spend time, get your team together in August, figure out who's going to be on it, and spend time practicing that. That way it's a little bit more natural, and the first time you're doing it isn't this memo.
So yes, that's an excellent idea, Ashley. And the way I tried with my team is I started working with them in August, and I sent them over email some of the winning memos from the previous year and gave them my year's problem, and then made them draft one issue, made some of the other team members draft other issue, and gave them rigorous comments over them. That really helps. And as Ashley puts it forth, that it will not sound as if they are doing it. It will not make them feel that they are doing it as something for the first time, but they'll have a bit of practice. Yes.
And it's also good practice because your oral argument is going to be structured the same exact way. So, if you nail this now, it's going to help you down the road when you start practicing actually arguing these issues. As far as sources go, you made a very good point, Sanya, with I think I blocked it out because I had such trauma from trying to get that table together. We went down to the wire. When I say we were last minute, we had like 2 minutes left to submit this before it was past deadline, just making sure we had our table put together. It's a lot of work. It's a lot more work than, like I said, I realized. But a related issue to that is make sure your sources are varied. You have no idea what kind of jurisdiction or what kind of practice your arbitrator is going to come from. They might prefer case law. They might prefer secondary sources. You want a solid mixture of both. That way you're appeasing both, categories of thought. So there will be case law on your issues. They will not draft a problem where there isn't some sort of case law that applies. It will be difficult to find most of them. You'll find some that you think are applicable. You'll argue it for a little bit, then realize that it doesn't really hit the issue on the head the way you'd like it to. And then you go back to searching. You're not just going to be researching just once. So for us, we did this memo and we thought we were done with our research. That was a joke. That was a very funny joke. Our research went up until we were arguing in Vienna, just trying to find other sources. You know, you hear another team argue something that you haven't heard before, or they argue a case or a source, and either you're looking it up because you want to be able to incorporate it into your own arguments, or you want to realize where it's flawed. That way, if you hear it again, you could say, haha, that does not apply here because X, Y, and Z. Either way, that requires you to be familiar with it. So vary your sources, because that's going to be critical when it comes to an oral argument part. You're going to want variations of different backgrounds, and you're going to end up tailoring what you argue based on what the composition of your tribunal looks like.
Yes, that's an excellent point that you made, Ashley, regarding having a mix of sources as well as being very well aware of the laws that you are going to use. So that's one thing that I would advise when you are arguing as well. If you're citing some case, then you need to know about the facts, about the jurisdiction where it was decided, maybe the year as well. Some of the judges do ask. I particularly had a bench in Belgrade. The president went to the extent of asking me the name of the judge, and I had it on the back of my mind, and I was able to tackle that questions. But that's something people struggle with. Then you also have to be prepared as to why you are using that case law, as to what portion is relevant, what are the facts of the case that are similar, or if not similar, then why is this case persuasive? Now, secondly, you have to make sure that you are not citing off-topic cases just because you just heard other teams. You need to understand why you should use them, why it will be beneficial, or whether you have a more recent case, or maybe if it was reversed in the recent time. So you need to be aware of the latest developments. So for example, in my Belgrade round, we had a team from Germany who was citing a case from the Indian jurisdiction, Indian Supreme Court, and I knew that was a case from 2013 and that had been overruled in 2014, and I was able to use that in my rebuttal, and that went very well with the tribunal. So that's some of the things that you can always ace through your research, etc., etc. Also make sure, and I generally see that this is a problem with the Indian students. And they think that XYZ will do the research and we'll just practice the oral round. That just doesn't go well. You need to read the cases on your own. You can't have any other person come up to you and tell you the summary of the cases, because then you'll just be having the summary in your head and you will not be knowing exactly as to why you are using that case. So that's one thing. Give
That's
time.
a really good point.
Yeah, that's
then you're just memorizing the information and not actually processing how it's applicable.
Exactly, because that's one of the things that we faced during in our team as well. That just doesn't work. You can't have some people come up to you, tell you the summary of the case, and you just can't go and sit there and present your oral arguments. And you'll be trapped when you'll be asked a question, and you'll be trapped even worse if you have some academicians on the tribunal. And and the other point that I want to put over here is that all of this competition is mainly based on luck. Luck is a very big factor over here. And when I say the word luck, I don't mean to say that we should not work hard, but it also depends on the tribunal that you get. You might get a very cold bench and maybe in the quarters, and then it's good, and maybe the other room that has your opponents gets a very hot bench and they get low scores. So luck is also a factor, but then don't get disheartened that what will happen if luck is not on our part. So just one way to tackle it is do your best, and at the end it's only your work that you can present in your argument. So just be prepared. That's what I could say.
By hot and cold, just to clarify, hot bench, they're asking you a bunch of questions to the point where it's almost going to derail you if you're not prepared, because you're trying to follow your argument as best as you can. You get a limited amount of time to get that argument out. So if you have judges asking you questions repetitively, you need to figure out how to answer those questions in a way that also gets your argument out. or you have a very cold bench, they're not asking you anything. And then your nerves end up turning on for the complete opposite reason. You're like, are they not interested? Am I not making sense? Why aren't they asking questions? Do I have their attention? Another thing that we did that I think helped with our submission, our written submissions, we started practicing oral arguments before we even wrote our memos. I think a lot of teams also get their memos out of the way, get their arguments lined up, and then practice. I honestly believe that it strengthened our written submission to start practicing our oral arguments first. Were we ready for our first internal round? Absolutely not. But you're never, first and foremost, you're never going to feel ready per se that early out. That shouldn't stop you from trying. But second, it helped us develop our arguments in our written submission, because arguing them out loud allowed us to see where our flaws were, flaws that we might not see when we're writing it because someone's not actually digesting the information and questioning you on it, or pushing back, or showing where there's holes in the argument that may not appear on paper. So that helped us go back and tweak our written submission in ways that strengthened it. Another huge advantage was when we did our first internal round, we did it for people that were not familiar with the question. They hadn't been doing the research with us. We were lucky enough to have professors that were very invested in our success, and we asked them to sit and listen. I know at that point, one of them had read through the question, but hadn't done any of the research themselves. And reading the question alone is not going to be enough to for me not to consider them an outsider at that point. And we had another professor who hadn't read it at all, was completely unfamiliar with what the question was, with what issues we were dealing with. Which, to be completely honest, there's going to be a lot of arbitrators in Vienna or virtually, however you're competing, who will not have read the prompt. They will not have read the material, or they read it on their flight to Vienna in the last minute, and they haven't actually digested it. So you're presenting it for the first time. You need to construct it in a way that they understand it, they're digesting it. You can't assume they're familiar with it. And that really helps you structure your arguments and shape the way you present them. So I would highly suggest starting internal rounds either while you're writing your claimant memo or right before you start writing your claimant memo to help you shape those arguments better.
Yeah, that's a great trick, Ashley. Actually, in India, actually, we see that the teams keep it to the last moment, maybe after the submission of the claimant memo, even both their memos. It's when that they start their oral arguments. It just doesn't help us. So the earlier we start, the better it is. And the way I did it with my team is I made them argue on the issues that we had from our edition of Moot. So kind of to know what they need to put in and what they need to improvise with regard to their oral skills. This issue with us Indians is with regard to our pace. So we need to manage that. I struggle with it. I still struggle with it when I'm speaking on a topic that I have an expertise upon. I tend to speak very fast. The only reason I might not be speaking fast right now, I mean, I'm still speaking fast as compared to what we require in Wiz. I'm speaking a little slower than, as compared to the pace in which I speak. The only reason being it's a topic that I'm not I don't claim to have an expertise upon. So, it just goes at the back of our mind. Our subconscious works that way, and we tend to speak really, really, really fast, and it gets very difficult for the person to follow. Specifically, if that person is half asleep, most of the times actually might be able to tell this. So we have a grand party in Vienna, and people are just hungover from the last night. They sit in the morning runs to arbitrate. They are hardly able to listen anything, and if you speak really fast, they are just going to give you negative marks, being like, okay, I don't know what that person is saying.
And keep in mind too, for many of these people, English is not their first language, and for many of the oralists, English is not their first language. So if you're speaking with an accent and now you're speaking fast to someone who English isn't their first language, they're already having difficulty trying to keep up and process it because it's not their first language. Now you're adding an accent and speed. That, like Sanya pointed out, many of the arbitrators have gone out the night before. They're enjoying Vienna. They're enjoying their time. They're hungover. They do not want to put the effort into trying to keep up with you and understanding what you say. So even the way I'm speaking now is too fast. You slow your pace down. You talk with purpose. You pause where there needs to be pause for them to reflect on what you just said. Everything you do and every way you do it is done with purpose. And it's not an easy skill to master. I don't believe I've mastered it yet, even with all the practice that we had at this. But it's a very, very valuable skill to take away from this competition. So I guess we can move on to talking about oral arguments. As many as you can, as frequently as you can. Do not get tied to your argument. It is going to change 1,000 times over. And when you get tied to it and you get this tunnel vision, you're going to miss out on other things that might be key that you might have overlooked. And it doesn't reflect well. You can tell when someone gets tied to an argument, particularly if an arbitrator starts to push them on it. And there's times to push back and be strong in what you're saying because they're looking to see of your conviction of your argument or whether you're going to shy away and you're not confident. They're testing to see your confidence. And there's other times where they really don't agree with you. And if you keep pushing back, well, lo and behold, you've just lost your 14 minutes fighting on that one topic that you haven't even persuaded them on because they came in to asking you that question with their mind already made up. So at some points, you have to learn how to say, I respectfully disagree, or to restructure your argument and say, well, if you're not buying this, then maybe you'll buy this argument. So if you have tunnel vision with one argument, you're not going to have those backups when you run into those arbitrators. So get ready to change your argument 17 times over. It's just the nature of the beast. And be open to it. That's a problem I had a little bit at the beginning. I found one way that in my mind was incredibly persuasive and I couldn't understand why someone else wouldn't see it as persuasive. My conviction doesn't make my argument stronger. It just makes me stubborn. So the best way to overcome this is practice. We probably did external rounds 4 times a week at least come end of January, I'd say, and internal rounds probably just as much. I'd say we had some sort of round going on every day of the week. You have to be flexible. If you really want to succeed, at least if you want to succeed. If you're doing this for fun, that's a different story. You don't need to put everything else on hold as much as if you really want to win. But our schedules became structured around when our VIS meetings were, pretty much, with the exception of class. We obviously wouldn't be missing class for this. There were times where I ended up late to some of my classes, and fortunately we had professors that understood and knew that it's because we were working hard. It wasn't because we were goofing off or slacking. But everything else, your schoolwork, your social life, other obligations you have, you really try and work around the best you can these rounds, these practice rounds, particularly if it's an external practice round. So when I say internal and external, I mean I'm practicing with Sanya against 2 of our own teammates, and we have professors judging, or we have other teammates judging, or we're fortunate enough to have classmates who participated the year before come in and act as arbitrators. When I say external round, I'm referring to we have managed to talk to another team and decided that our teams are going to practice against each other. I highly, highly, highly recommend finding other teams willing to practice with you. Even if it means your hours are really crazy. We had one particular round against Sri Lanka where it was a Sunday morning and I was getting up at 6 a.m. to make an argument just because the time zones varied so significantly. But that is the best way to expose yourself to other arguments that you might not have thought of. Once your team kind of gets set on their arguments, you don't really see outside that scope. You don't have different minds coming in and giving you feedback or giving you new ideas that how they've read the problem, how they've perceived an issue, maybe other sources that you haven't found in your research that get brought up in this practice argument that you now want to go research. And it also kind of helps you get used to the idea of arguing in front of people you're not comfortable with, which is something you need to do over and over and over again to prepare to argue in front of an arbitration panel that you've never seen before in your life. So I would highly emphasize that as you develop networks, keep in touch because it's going to help teams down the road for your university. That was a big, big help for us. The team a year or two, the year before ours, became very close with a team from Passau. And we were able to do several rounds with them just because our coaches were friends with their coaches because they had competed against each other in prior VIS Moot competitions. It's very, very beneficial. And then the last thing I'll say on practicing your arguments, like I said, don't be attached. So what Sanya was saying about the structure, this is our conclusion. These are our 3 points. Again, this is our conclusion. Moving to issue 1, this is what we want to talk about. The judge might derail you with a question that really belongs in issue 2. Don't put the judge off. Don't say, I'm going to talk about that down the road. You're just going to piss the judge off. Assume that they feel that they're inferior to you or superior, excuse me. Assume that they feel that they are superior to you, and you have to oblige to them. So you're going to confidently just move to your second argument and argue it a little bit backwards, and then say, okay, recalling my first argument, or you move backwards after you've answered their question, or you've laid out your second argument if it's related to their question, because now it's saved you on time. You've appeased your arbitrator. One thing that one of our best oralists did that I thought was very helpful, she recorded herself arguing and listened to that recording over and over and over again. You need to memorize your baseline argument. You can't be tied to it because you're going to have to make tweaks as you go, as you learn new information, and as judges ask you questions that are going to derail the order that you were going in. But it becomes difficult to switch up, okay, well, then I'm going to go to issue 2 and come back to issue 1 if you don't have it memorized in the first place. So one of our teammates recorded herself arguing and just played it in her headphones and listened to it over and over and over again. It helped her learn where her pace picked up. It helped her learn where she should pause to inflect. It helped her figure out where she had holes in her argument, or where she needed to maybe change course because it didn't flow the way she wanted it to flow. Hearing yourself helps tremendously. I thought I'd sound smooth with something, and I'd listen to a recording and be like, oh, geez. And that was another big thing our coaches had us do. They recorded all the internal arguments and external arguments that they could possibly record. And as part of our homework, we had to go back and watch it and look where we made mistakes, try and figure out how we could have addressed something differently when asked a question that we floundered on. That way, it wouldn't happen again down the road. So there's a lot to be had with the oral argument part as well. Things aren't easier because you've done your memos and your research, and now you should know it. There's a lot of work that goes into it. Even just practicing proper form, your speed, the way you're sitting up straight. You're not fiddling with your hands. You're not fiddling with your pen. Learning your teammate well enough to know their argument too. It's not substantial for you to just know your own argument, because you're going to have to be able to help your teammate. So we practiced writing notes, and particularly with time. Whatever your teammate was comfortable with, if they wanted a 7-minute warning, because they knew at 7 minutes they had to move to that second argument no matter what, you just calmly and slowly slid a note in front of their binder saying, 7 minutes remaining. That way they're not looking at their own clock. They're not trying to keep pace without any idea of what their time is at, because it will go a lot quicker. It's 14 minutes, sounds like a lot to argue. It is not. It flies. So you need to be aware of your time. There's one other point that has slipped my brain at this point. If you want to comment on practicing the oral round, Sanya.
Yeah. So actually, when you talked about the notes, then you really have to have your partner collaborate with you. That's one thing that we struggle with in our team. So there was one round when one of my teammates didn't tell me anything about the time. I actually did not know when to ask for the extra time. So that's one of the things that you'll have to collaborate amongst each other. And, it goes for every team at large. If you're not comfortable with your team members, speak up at the first instance. Your mind will not let you argue. Even if you are a great oralist, your mind will not let you argue. You'll have a panic attack, a mental breakdown in the middle of it. You might sweat to death if you're uncomfortable, specifically if it's one of your male members. Maybe things like that do happen, and we just cannot say that these things do not happen. Maybe we don't speak about that, but we should speak about that right at the starting, so that we do not have to suffer till the end. You need to keep your mind very free when you are arguing. For me, what worked the best, me and Ashley, we had these early morning rounds, and she had a cup of coffee. For me, coffee didn't work. I don't know. I used to feel sleepy when I took a cup of coffee. That's strange, but it didn't work for me. For me, tea worked. So, even before leaving my home, I used to sip a cup of tea and things like that. Do whatever helps you get into that role. And you need to understand just one thing, then when you are in that round, you are in, as one of our coaches also said, you are in a different and altogether different zone. And you are your normal self, once you are out of that war zone. So you just have to when I used to shift into that war zone was when I used to straighten my back. That's one thing Indians struggle with. Even now I'm sitting comfortably. So that was so difficult for me. I'm sure it will be for other Indians as well. That was so difficult for me that the moment I straightened up my back and used to keep my chin up, I just had in my mind that, Sanya, you're going into a war now. That helped me set up.
That's a very good point. Have a cue for yourself, for your brain to learn that when I do this, it's go time.
Yeah. So that's one of the things how we can, train our brains as well. I see some of the teams struggling with time management. So one thing that we can always have ready with us is a conclusion of the second issue. So in our year, our arguments were there were two issues from the side of procedure, one issue from the side of substance, but generally every year it's 2:2, but it was a bit different for us in that year. So we always had a short, crisp and short summary of the second argument prepared in, for example, if we have exhausted our 13 minutes in the first issue, so we don't leave the second issue untouched, and then we at least have delivered the conclusion. Now, be aware of this thing that you might get questions from the arbitrators, even when you have exhausted your time limit, then you can just ask them for extra time, and the time it has to be a good tactics as to when you are asking for time. So you can't just ask time at the 15th minute or maybe just 30 seconds before you are going to exhaust your 14 minutes. So it's preferable for you to ask time at 12th minute or maybe 12 minutes, 30 seconds, something. So just it just shows that you are aware of your time as well. It just shows the arbitrators that, it's not just us who are keeping the time. That person is also aware of their time being exhausted. So some of the things that you will get to master over and over again when you practice with amongst yourself or maybe other teams. And just one last point to make. So when you're practicing with many other teams from different jurisdictions, so it helps you in this regard, because some of the arguments might work very well with some of the teams, and some of the arguments, the same arguments, might just not work for some other teams. So it will help you come across with a common argument, how to neutralize your argument so that it works across the board. Maybe even if it's an arbitrator from Italy or it's an arbitrator from a country from Middle East, your arguments, over the time, it will get so neutral that it will work with both. So that's one of the most beautiful advantage that you will get through external practices.
Yes, most definitely. There are 3 other points that I'm going to make in the interest of time, try and condense them, because there's so much that can be discussed about the moot. And if anybody listening would like to discuss some of these tips and advice further, I'm more than happy. You can find me on LinkedIn. One thing that was asked of us was, are there any particular scholars that you should research that are always applicable? And there's just 2 that came to mind right away: Christopher Bonnell and Gary Bourne. Those are 2 big ones that seem to always come up. Now, as far as the actual oral arguments, I recalled the point I wanted to make earlier. We reprinted out the contract itself and all the pages that came with the problem, and we had what we called our argument binder. We would take a highlighter, one color for respondent and one color for claimant, because you will have to be able to argue both sides. And when you're competing, you don't find out until right beforehand which side that you're going to be arguing for. So you need to know the arguments for both sides, inside and out. When you're arguing, you need to refer to the resources given to you. So the actual problem itself. The judges want to see that. They want to see you rely on the evidence, which makes perfect sense. In any actual practice, you need to present evidence. And it's not just going to be, well, this person says this and this person says this. Why is what they say applicable? Well, if you turn to page 12 of our documents, and it shows an email, and paragraph 3, line 4, so-and-so said this sentence, and this is applicable because, or this is how we interpret it based on what Gary Bourne says. you really need to be able to look at the actual documents. We had a quiz on it. We had to pretty much memorize where was what, and it was difficult. Our first quiz, none of us performed well on. I think the highest percentage was like a 33% out of 100 for several questions that we had. I forget how many questions our coach put on our quiz. You want to know it inside and out. For me, I made flashcards of each paragraph for each page. On one side, I put what page it was, what paragraph, even down to what sentence. On the other side, I put what it was. That way I had a general idea. And then when you go through it and highlight it based on what arguments work for your respondent, what arguments work for claimant. So you had a claimant binder and a respondent binder with the highlights. At the very least, I knew the exact page I needed to turn to, and then it would pop out at me. So if I all of a sudden I'm stuttering and I'm nervous, I can remember to tell the tribunal to turn to page 13. But if I can't remember what paragraph, it's highlighted. It's going to jump out at me. And I was like, oh yeah, it's paragraph 3. A big pointer with going to the actual record, wait for the tribunal. Do not say to turn to page 13, then start reading it before the tribunal gets there. They will have a copy of the record. They are going to want to read along with you. If they're flipping through pages as you read it, they're not listening to you or the argument. You pause. It shows a respect for the arbitrator. They appreciate it. Are you sweating because it's taking up some of your time, especially if you have an older arbitrator who's futzing through it very slowly? Yes. But you've won the arbitrator over, which at the end of the day is the goal. Because now he's like, okay, they've had the respect and patience to wait for me. They understand me following along is important. And you're going to win over in the sense that they're going to like you as a person, which is a very big deal. And in law, whether you're practicing arbitration or you're practicing in a trial room in the US, being personable and selling yourself and being relatable in that sense is going to go to great lengths to help you win your argument because the person finds you likable. So pause when turning your record. We also had notes. We didn't just have our record. I had a list of different quotes. So like the court cases, if you had a hard time memorizing that and you just think, I'm not someone who can memorize this, don't completely disregard it. Does it look better if the arbitrator asks you, well, what were the facts and what was the year and what was this? For you to just turn around and answer, keeping eye contact? Of course it looks better. But if you know you can't do that and you're gonna flounder and it's gonna look bad, you're better off looking down and saying and looking at a note that says, you highlighted the case and then under it, oh, of course, Your Honor, look down, or presiding arbitrator, Mr. Arbitrator. Sorry, I've lost my arbitration skills being in front of courtrooms now. Of course, Mr. Arbitrator, and you look down. That case was in 2012. It was presented before this court, yada, 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 yada. So you still get points for having the information and being able to answer his question. Do you get the little, edge of knowing it off the top of your head? No, but you also didn't look like you were floundering. You were able to actually appropriately apply the research that you've done. One last thing. You will learn your arbitrators' names. Do your best to use them. I had a very hard time with this, particularly with trying to pronounce names from different countries. The US is notoriously bad for that and butchering the pronunciation of people's names. But if you don't know how to pronounce it, one trick that one of our coaches taught us, particularly when you're in Vienna, you can go up because you're going to hand over your little business card and get their business card. You shake hands, say hello. I don't know if you'll be shaking hands post-corona, but you can still be introducing yourselves. And you can say, it's a pleasure to meet you, and ask them how they pronounce it or try and say it and see if they correct you. So at that point, now you have the correct pronunciation. And for me, when the arbitrators then again introduced themselves in the panel, it reiterated it, but I would take their business cards and lay it in front of me, or I would write it on a piece of paper before we started in front of each arbitrator. So I knew their name. So when they address you, if it's Sanya, who's my arbitrator, and she's now asking me a question, I could say, yes, Miss Kishwar. The answer is X, Y, Z. The answer is this. It's another personal touch that goes a long way with the arbitrators to make it more personal. I don't know if you want to touch on that at all, Sanya. I think I hit everything I wanted there, or at least everything that I think is, of most importance to making great strides in a stronger argument.
Just one point over there. So when we are meeting our opponent team for the first time in the room, then we have to discuss regarding the order of the proceedings as well. So there might be some notorious teams which will make you reverse the order, and that might come up to you as something that might make you have an anxiety attack. But just relax there. You just have to switch your roles, nothing else. No, not even roles. You just have to switch the order. At the end of the day, you are saying the same thing, but in a reversed order. So that's nothing to worry about. Now, regarding the oral... Yeah.
So I think it's something more nerve-wracking for substance, because 9 times out of 10, substance ends up going second. So Sanya would introduce both of us. She'd ask the arbitrators if they wanted some of the facts. And at that point would, if they said yes, she would give a brief summary of what has happened, why we're here, and then proceed to her arguments. Some teams will say, well, we want substance to go first. Now, for me, I was substance. I'd be like, oh my God, because you get so used to this routine of, okay, I'm listening to Sanya, I'm helping Sanya. Towards the end of her argument, I'm starting to, like she said, well, I'm already sitting right, but I'm kind of getting my head in the game, getting ready to argue. Now I'm kind of getting blindsided and saying, oh, well, you're going to argue first. And it's like, now I have to resuscitate the facts. I have to regurgitate the facts and introduce us, which is not something I have as much practice with because Sanya always does it. Like she said, it's not a big deal. Just make sure everybody on your team is able to recite, a quick statement of the facts and why we're here, introduce the parties, and move on. But if you're not ready for that, it will catch you off guard. Good point, Sanya.
And we also have to be prepared about the substance. If you are a procedure speaker, we need to be prepared on some of the major questions from the substance side and vice versa. So we had a round in Fordham where the substance speaker was asked very, very procedure specific questions, and I had notes. I prepared notes, gave him the answer. It just works well if you are able to tackle, help your team member in that way. It also shows team collaboration that also gets you points. So one other point in this regard. So Ashley also talked about one of our team members hearing her recording, maybe there might be times when you might not get enough time for yourself to practice because as Abhishek also told in the beginning that we have a cap of team members, so sometimes we have 3 members who are arguing as well as researching, so we might not get enough time because as it went in our team, some of the team members had very little to zero load of researching. Some of our team members had a lot of load on researching specifically for procedure side. So it just didn't go well with some of our speakers to even get time to practice their oral arguments to such great extent, and just led to their crashing. And, as Ashley also told that we need to put a lot of time in making the table of contents and putting together the arguments, making the uniform citations, and of course team members do that. So the one who is doing this and the ones who are not contributing equally, the load on one person or 2 person is huge. So whenever you're building a team, you need to make sure that everyone does the work and the distribution of the load is equal, so that one person is not exhausted at the end and doesn't crash during an oral argument. So that's something that we might take into consideration when we are dividing team tasks. And last point regarding some of the scholars that you might need to look after, the books that you might need to have in your library. So Ashley very well pointed out Gary Bourne, and I might want to add a few more. When Sinma, for example, if you have questions regarding evidence taking, etc. I don't know how to pronounce the author's name, but Hanoshio. I don't know how to pronounce his name, and I'll just if you want, I can send your team a list of the authors as well. So we have Liu, we have I just don't have it at the top of my head. Redfern and Hunter, right? Redfern and Hunter. We had Schwenzer. We had Gelard. We had, I don't know how to pronounce it again. Gelard. Gellard. It's a French author, Emmanuel Gellard. I don't know how to pronounce it again, a French name.
You'll find a lot more consistency with the authors on procedure, because the question doesn't, like, there's only so many questions that they can ask. Substance, I'd say there's one or two that are strong, but it's going to vary more likely just because there's so much more that could be touched on. Like for our year, there was an issue on gap filling and whether a certain set of rules could fill a gap in another set of rules. That's going to have completely different authors that have focused their career on those kinds of questions versus another issue.
Yeah, exactly. So it's also issue specific. For example, this year we have the SIAC, and I had one of the oralists who was arguing before me. She actually used the HKIAC rules as one of the soft laws, and she said that it's persuasive. But when you are using soft laws, they need to be at least related, and they need to be have addressed as something that has a label of soft law by authors by authors at large. So the way she was structuring her arguments was a bit strange to me, because if HKIAC cannot in any case function as a soft law, even if you are arguing before a tribunal that's following SIAC. So you need to, get a thorough with the soft laws, IBA guidelines, maybe have a few readings of some articles on ethics, arbitrator, impartiality of arbitrators, if that's something which is in your arguments. And if you are having a question on ethics of arbitration, you can very well refer to works by Professor Catherine Rogers. She was our faculty coach as well. So she, as Ashley said, someone who has given their life in research, in researching on those topics. So you need to do those basic research beforehand when you are reading about arbitration over and over again. So yeah, that's something I wanted to add. That's pretty much it. Sorry.
The last thing I'll say that's short and sweet. If you need arbitrators, don't hesitate to reach out to former competitors. You might not hear back. Some might be willing, myself included. If you were to reach out to me and ask if I would arbitrate an internal round for a team, I'd be happy to. I just want to see people learn and be successful. The BSc Moot taught me a significant amount and really challenged me. I learned what my workload and my capability is. It's very beneficial. It's worth doing. And if you need that external help, don't be shy to reach out to people who have done it before. And if someone doesn't answer, don't, stop reaching out to others. In that sense, it's similar to applying for jobs. If you don't hear back, you don't stop applying. You just look elsewhere. So, like I said, I'm happy to help. You can find me on LinkedIn. And that's all I have to say. If Sanya, if you have anything else, or else we can move to some of the questions.
All that I had from my side as well. Yeah, we can move ahead to the questions.
All right. I
apologize for how lengthy that is, but the BSc Moot is a lot.
Oh, no, I'm sure. And I'm sure that if we actually had more time, I'm sure you would have actually spoken a lot more. But trust me, I think that was a very, very detailed session. So thanks a lot to both of you for sharing your insights on that. I do have a couple of questions, but I understand that I'll need to make this quick. So my first question is actually with respect to when a student is choosing a moot court competition, they really, really want to understand as to what exactly are they going to get from this moot, not only in terms of learning and exposure, but also in terms of the opportunities that it may open up for them after they've completed the moot, whether or not they've necessarily won it. So would you want to elaborate a little bit about the new things that this opens up to you?
Absolutely. For myself, I haven't career-wise gone down that path per se. I know previous BSc Mooters have. I know some people have gotten some higher up jobs because of exposure at the BSc, because when you go to the BSc Moot, there are a lot of firms there that have not only funded the competition, but they're actively recruiting for new members of the firm. So if you perform well, you might find it might not land you a job, but it's going to open that door for discussion. For myself, the big takeaway, like I said earlier, was how many connections I've made worldwide networking. I'm a big traveler. I love having friends in different countries. I love experiencing different culture. So giving a common ground for me to start a conversation with someone in Buenos Aires, in Liberia, in, these countries that I normally wouldn't have contact with. I'd have no way of making contact with. I've now maintained friendships, and we're almost 2 years out from when we won. And there's still people that I keep in touch with. Once this virus ends, there's people that I plan on visiting, which is not a benefit academically or career-wise related, but enriching your life is something that's, I think, just as important, and it's certainly enriched mine.
Yeah, I would like to just add, I do believe that you might be exposed to some options of getting scholarships, maybe, or maybe getting some more contacts when you are attending the seminars that they have, when they have some parallel seminars that they run even during the Viz week as well. So that's an excellent thing that excellent opportunity that you get. Besides that, taking it approaching it through the other side, you might get clearer on what career you want and what career you do not want if you participate in the Viz. So for me, when I started doing the Viz, I was like, okay, arbitration is a good field. It's lucrative. People get money. I think I can get deeper into it. Maybe I can have a career. But when I went deeper and deeper into that, I understood that it just doesn't suit my personality, because I tend to approach things with a very elaborate perspective, and that's just not something that works with arbitration. You have to be crisp, on point, succinct. That just doesn't work with my personality. So it helped me get clearer as to what path I should choose. So that, as Ashley said, that it will be a life enriching experience. And now you see where I am working as a faculty in law in a totally different subject matter, international human rights. So this actually helped me to understand that arbitration is not my thing. So that's one of the other things that you can see. But yeah, for Indian teams, maybe one thing that I'll give you a heads up, we have this tradition of getting big trophies and medals. Don't expect anything from this. You just get a certificate. We as winners literally just got a certificate of winning. Full stop. No prize money, nothing. Indian teams
t-shirt. Yeah. Don't forget our awesome blue free t-shirts. And
I didn't get that. I didn't get that even, because I was not there attending some personal mishap at my home. I was not there. No one cared to give me that t-shirt, not even my coaches.
I have an extra. I can mail it to you.
No, that's just a joke. So the thing, if the Indian teams are going there thinking that we'll get a huge sum of money, no, zero, nothing. You'll not get literally nothing. Not even a medal, not even a shield.
Just an example to Sanya's point, Penn State has one of our program directors for the LL.Ms actively there recruiting, looking for new LL.M students to join Penn State in the following year. So it's definitely worth it if you're thinking about an LL.M, particularly one from the US. I know at the very least Penn State is there, and he is on the hunt looking for new LL.M students.
And yeah, just a heads up for any student who is trying to apply to Penn State. We don't have a specialization for students who are pursuing their LL.M. We don't have a dissertation program. So that's something that will come to you as a shock when you will actually be taking your LL.M. program. You'll be expecting to have a dissertation. Just keep that in mind when you are applying. And if you want to apply for experience, etc., then it's a very good option. But if you're actually applying for having a dissertation, that's not something that Penn State offers. At least not for my batch. We didn't have a dissertation writing. So that's something different from what we expect in our LL.M programs in India or maybe in UK. So yeah, just a heads up.
I think that's a very interesting insight, and thanks for both of your answers to that. So I think now I'm going to move. I'm randomly going to move a little bit into more of oral prep. So I think the first question that I have with respect to this is, how exactly do you think, in fact, that there is a difference in the method of preparation for a speaker who's focusing on the substantive and another speaker who's focusing on the procedural, and maybe how should they go about this division when they're actually preparing for their oral rounds?
I would say the only difference is in the actual substance of your arguments. The way you present them is going to be the same. Your mannerisms, how you should be speaking, how you should be sitting, what your teammate expects of you as far as passing notes when they're speaking, helping them I got to the point where I would know my teammates' argument well enough where if I knew they were going to the record, page 13, I would turn the record for them. They never actually touched the book. Your teammate did it for you. That way your focus stayed on the arbitrators. But as far as difference in preparation, it's different arguments that you need to know inside and out and different research. I would say that's the substantive difference, is the actual focus of your arguments.
Yeah, and I would just like to add over here, so as the procedure speaker goes first when we are arguing from the side of respondent, so they have to be prepared with other things as well, like a basic introduction to the facts of the case. They have to be prepared about giving an introduction to the teammates, stating the order of the proceedings. For example, if I'm here in around here, so if I'm a speaker from the procedure side and I'm arguing from the side of respondent, so I'll start with, good afternoon, good afternoon, members of the tribunal, esteemed colleagues. My name is Sanya Kishwar, and together with my co-counsel Ashley Clasen, we represent a respondent in today's proceeding. Right. So this is an introduction given by the first speaker, and they actually have to then go ahead and say, we have argued that we'll go first with respondent, followed by claimant. We'll take 14 minutes for the arguments, 1 minute for rebuttal, and the same order and time allocation has been discussed with regard to our opponent team. And if the tribunal, if it pleases the tribunal, would they want a brief summary of the facts? So these are something, some of the formal things, formal requirements that the procedure speaker has to be well versed with, because they'll be the one who will be introducing the team as well. So yeah, and apart from that, it just goes with the substance of the things that you speak. Yeah.
One point that we did miss, you have to request time for rebuttal. You could get a panel that if you forget to request it, they'll say, I'm sorry, like, you're not getting your rebuttal, you didn't actually request it. So be sure to request that at the beginning.
Yeah, so we have to state if we are keeping 1 minute or 2 minutes for rebuttal. Yeah, and then it goes for the rebuttal as well. Even if we have 1 minute for rebuttal, we just have to utilize 30 seconds. We have to make one crisp point for rebuttal and not utilize the whole 1 minute for rebuttal. And then you might have seen teams using 2 points for rebuttal. That just doesn't work well. So you just have to make 1 point. And how do you choose that 1 point? For example, if you have a team that makes a mistake of stating the law and makes a mistake of stating the fact. So you have to compare these two mistakes, and obviously misstating a law is more grievous of an offense than stating the facts maybe, and that's something you want the judges to know. See, they don't even know the law that they're using. So that's how you just pinpoint one thing.
Although it's going a bit off topic now, with your rebuttal, make sure it's actually in response to something they said. You're not introducing new arguments here. That is an absolute no-no.
Yep, I think thanks for that insight. And thank you, Sanya, for actually giving us a glimpse of your oral pleadings. That was wonderful. So thanks for that. I think this brings me to my last question, and also I think one of the trickiest questions for any team to ever answer. So could you, I want both of you to answer this individually. So what do you think is the right response to when a judge asks you a question and you have absolutely no idea as to what exactly is going on?
That's happened to me. And at that point, you don't make it up. You don't flounder. That's not going to look good, especially if they decide to start pressing you on it and you don't know and you've made something up. Best thing you could do is say, I'm unfamiliar with that case, or I'm unfamiliar, with that the answer you're seeking. I'll have to get back to you with a memo later. Basically, what you would do in real life, you'd say, I need to go research it. So I'm going to have to address that issue in a separate memo that I'm going to email to you. Obviously, you don't want to say all that. That's wordy and it's going to take up time. So you just say, I'm sorry, Mr. Arbitrator, I'm going to have to address that issue in a memo to you at a later date. Short, simple. He knows not to push it because you don't know it, and you get to move on with your argument. Does it look good that you don't know it? Not necessarily, but you will, in a sense, get points for being upfront and honest about the fact that you're unaware.
I remember Professor Dempsey gave a very good insight to us in this regard when he was helping us with a practice round, and one of our teammates just absolutely lied about the law, and it was a very low point for our team then. So he said, be truthful. So as Ashley said, if you don't know, I have zero idea, but don't make it up. That's the thing that our teammate did, and it just looked so bad. The tribunals get so upset that what do you think, we are idiots over here and we don't know law? So just don't, and you can just say, I apologize, Mr. Arbitrator. I'll give more inputs to the tribunal later. But yes, it will not look good, but at least it's better than lying. So, yeah.
Yep. I think that makes sense. And thanks for that answer. So I think with that probably brings us to the end of this session and the end of the Q&A session too. I would just like to take this opportunity to thank both of you to actually take the time out for this really informative session. Trust me when I say that this is going to be really useful for teams in the future that actually want to consider taking this moot up, and also teams that are already doing this moot and just want some more idea as to how they should go about it. So thanks a lot for taking the time out for this session.
I sorry to interrupt. I just have a quick point over here. I think I missed that when I was telling about oral preparations. So regarding claimant side, when you are arguing from the side of procedure, and regarding the respondent side, and if you are arguing from the side of substance, then these two speakers have to be prepared in answering the argument. So the way it goes is the speaker from the side of claimant, who is speaking from the side on the issues on procedure, is actually replying to the arguments that the respondent already made. So that's one thing that you have to keep in mind. Same goes for substance as well. So you actually have to declare at the starting whether you will be replying to the arguments from the side of respondent in the order that they presented or not. If you're a procedure speaker, you have to give the judges a heads up as to what will be the order in which you will be replying. And while you're replying, you need to touch on all the points. Sometimes we do this common mistake of not following the structure that the respondents presented. Maybe they did not even touch upon one issue, and you are there as a claimant responding to something that they didn't even touch upon. So it just does come out as you didn't even hear what the respondents were speaking. So that's one point when you are a speaker who is replying to someone else's arguments. Yeah,
that's a really good point we missed. The best thing to do is literally be taking notes when your opponent's arguing. Outline their roadmap. That way you know you're hitting it when you go to speak.
For example, in the round we had in Fordham, we had a team which touched upon the second issue first and touched upon the first issue at the end, just as a conclusion. But we had our claimants' arguments structured in such a way that we had the first issue in detail and second issue as a conclusion. So I had to switch, and I had to do it in just one moment. And I had to elaborately present the second issue and present it first, just to show that I was actually listening to the respondent's speaker when she was arguing. So yeah, just that one point that I thought that we missed.
Nope. I think thanks a lot. I think every single point that you're adding is a huge addition for the teams that are actually taking part in this. So it makes a huge difference to them. So thanks again. And yep, I think with that, I officially would want to bring this session to an end. And I really thank both of you for taking the time out for this lovely session. It was a very informative and detailed session. And I really thank you for sharing some of your secrets and insights with respect to how to do good at this moot.
Thank you.